Welcome to Ground Rules, Employment Law over your coffee break. My name's Pam Howland, and I'm here today with Doug Plass and Jennifer Walrath. And we are diving in today to talk about what I think is one of the most confusing employment law issues that employers have to follow. And as if the ADA isn't hard enough to understand and comply with, we have this complicated concept under the ADA called regarded as discrimination. So, we want to talk a little bit about that today because that issue does come up. I wouldn't say regularly, but once in a while in our practice. And we actually handled some litigation a few years back where that was one of the key issues that resulted in heated, litigation spanning 5 years, I would say. It ended up in a court trial and a Ninth Circuit appeal. And so we know a little bit about regarded as discrimination under the ADA. And we want to share some of that knowledge and some practice pointers and some ideas with you about that. One area that we see this arising in the workplace involves drug and alcohol concerns, and another is mental health. Of course, those aren't the only places that this arises, but we'll give you a couple of examples where we've seen it come up. And then we want to give you some ideas on, what this really means and how you as an employer can make sure you're complying with the ADA when it comes to this crazy complicated concept of regarded as discrimination. So Jennifer, Doug, more ideas, more like substantive comments kind of on what this is and how this trips employers up in the workplace.
Well, I was just going to kind of start with like a kind of a simple example, just to kind of give context for what we're talking about, right? So, if you are an employer, maybe you find out that one of your employees was recently in the hospital, uh, maybe for heart palpitations and shortness of breath. That person comes out of the hospital, has no diagnosed condition, but you're aware that happened and kind of assume that that means the employee is going to struggle doing their job. Maybe their job even has some, physical functions and expectations. You're just really concerned about, hey, this employee was just in the hospital. What if they overexert themselves? Something happens at work. We're just really concerned about that. And, try to get that employee to resign. I think that is something that is a scenario that certainly can happen in workplaces or something along those lines. And that is exactly the kind of thing that we're talking about here. Because if the employer were to say to that employee, we need you to quit, that employer may well have just violated the ADA because they made a decision about how to treat that employee based on an assumption that that employee had a medical condition and that that condition would affect them at work and mean they wouldn't be able to do their job as well. So that is really what we're talking about here. And I think one of the biggest points that I wanted to kind of highlight today, and we talk about this all the time with the ADA, but it has kind of, it's particularly important in this area, is to not make assumptions about, what condition somebody may or may not have, whether some performance issue or conduct issue you're seeing is because of some medical condition or a disability, or even, what the solution would be if someone has, a disability or medical condition. So basically, assumptions can be very dangerous. Don't make decisions based on them. And luckily for employers, the ADA gives you tools that you can use in order to make decisions that are actually grounded in good information provided by the employee, or provided by the employee's healthcare provider. So I know we're going to talk more about that today, but I think that really is one of the biggest takeaways about the ADA overall, but in particular in the regarded as area, is just do not make decisions based on assumptions.
Yeah, I totally agree with what Jennifer just said. I mean, I think that um, the way our brains work is we extrapolate from incomplete information. That's just kind of what we do going through our our days, and employers do this a lot. And you see that an employee has something going on with them, whether it's some sort of physical thing, or whether know that they are having some personal struggles or something like that, and you immediately go to, oh gosh, this is a problem. How can I solve this? Pump the brakes, right? Jennifer's right. Do not make assumptions. Instead, what you want to do is ask questions. You want to say, I see you're having a performance issue. What can I do to help? You mentioned something to me about some problem you were having. What can I do to help? How can I help is always the right answer under the ADA. And don't short circuit the process. The reason that the ADA exists is to allow for an individualized determination as to what each individual employee needs to be able to do their job. So let that happen, and don't jump ahead to the next step before you have all the information. And that's how employees get themselves into trouble with regarded as claims, by jumping to the next step without having complete information to move on.
Yeah, those are good examples. So we know that under the ADA, a person is considered to have a disability if they have a physical or a mental impairment that substantially limits a major life activity. But what you may not realize is that the ADA also protects people who maybe don't meet that definition, but the employer thinks that they do. And where we see that come up frequently is when maybe the HR person who handles ADA accommodations gets a report by coworkers that something's going on in the workplace. So maybe a coworker goes to HR and says, "Hey, did you know that Joe was in the hospital?" That was Jennifer's example. Or, "Hey, did you know that Linda is looking impaired in the workplace?" I mean, those are the types of things that can trigger regarded as disability discrimination. So, like the example that we have, like one of them from a real life case that took a whole lot of time and effort to resolve, uh, arose in that very context. So, it involved a supervisor who had an employee, and that employee had surgery, uh, major surgery. And when the employee returned to work after a leave to recover, there were some observations that that employee was impaired in the workplace, was acting strangely, was just not doing what they would normally do. Various employees came to the supervisor and expressed concerns, and the employer uh, was concerned that there was some type of addiction to a painkiller following that surgery that was going on there. So the client had eventually like tried to take advantage of tools provided by the ADA, including this whole concept of the ability to get a fitness for duty examination. And it was that conduct by the employer of placing someone on leave pending a fitness for duty examination that triggered this claim by the employee that they were wrongly regarded as being a drug addict. So that's one example of how this can arise in the workplace is coworker observations and an employer kind of piecing together where an employee's been and what they've done, and then reaching a conclusion as to what might be going on where that can cause mischief under this concept of the ADA. So, another example of that we've seen involves mental health in the workplace. So, you've now probably heard us say on at least a handful of our podcast episodes how broad the ADA is and how mental health frequently is covered. We know that the EEOC has said mental health conditions are covered under the ADA. So imagine if you have an employee who suddenly appears to have some type of performance change. And that's how a lot of these things arise, right? Is an employee who's performing okay suddenly goes through a change and now they're not performing okay. And the employer's looking at that, trying to figure out what's going on. So, in the mental health arena, imagine that if you have an employee who undergoes a performance change like that, they're telling coworkers, I'm anxious, I can't be around people, I'm not sleeping, I need to work from home. And an employer, a supervisor somewhere starts thinking, okay, I've seen this before because my nephew has bipolar disorder. Clearly, that's what's going on here. Or someone takes their own personal experience and says, okay, my sister has PTSD. Obviously, that's what's happening here. And then the employer makes some kind of decision based on that assumption. That's what can run afoul of this whole concept of regarded as disability discrimination.
And as Pam was talking, there are a couple things that occurred to me. I think there are a couple of impulses that some employers have that can make it easier to kind of make these kinds of assumptions. And one is, a lot of employers care about their employees. They want to help them. And while, kind of a laudable thing, it can get employers in trouble sometimes in the workplace if they are, kind of being overly insistent on helping somebody who maybe hasn't come to them for help or hasn't asked for anything. And kind of a companion to that is that sometimes you'll get an employee where they are very clearly struggling in some way. Whether it is performance, like Pam mentioned, like a change in performance where it's been very noticeable that they are not doing as well as they once were, or they're having conduct issues and behaving in ways that they did not previously behave. And maybe, the employer knows something about that employee or something that happened recently. Like maybe they had a recent traumatic event or had a traumatic event in their past. And, they're assuming, well, this could be like PTSD. And maybe the employer does the right thing and goes to the employee and says, hi, we've noticed that, you've been having X performance issue or conduct issue. We need to address this. Is there anything we can do to help? And the employee does not identify anything having to do with a disability. And for a lot of employers, that's a very tough thing because they want to, like Doug was saying, fix the problem and assume the problem is an underlying disability. And, really the right thing to do is to say, okay, and if you ask them if they need help and they say no, then document that, put it in the file, and maybe invite them that, down the road, if anything changes or they need anything, door is always open, come ask us. But I do think that's a really hard thing for a lot of employers to have an employee where they are just convinced that this individual has some disability or medical condition that's affecting them at work. And the employee says, no, I don't have any issue and I'm fine and I don't need anything from you. And a lot of employers just, that's not a comfortable place to be. But you've done the right thing if you've asked the question and you've been told that there's not a need for anything. Now, I will caveat, right, because we're lawyers and that's what happens. But there are some times where there's a safety concern or something serious happening where like you can't ignore whatever is happening. But we're not talking about that today. But just be aware, sometimes if there is something very serious happening in the workplace, an employer may have to take action, but there are certain, I guess, standards, certain factors to take into consideration to decide whether or not it is necessary to do something. And that's a really tough, tricky issue that I'm sure we'll talk about in a future podcast.
Yeah, always safe to say, how can we help? Like Jennifer said, sometimes we'll have employers call and say, what do we do with this? What can we do? What can't we do? That's always the safety net. It's always okay to say, what can we do to help? And that really is the one thing you can do that's not going to cause you problems. So if you see a performance issue, that's your first line of defense.
Yeah, and that, I did wanted to mention kind of the other side of regarded as disabilities, not having to do with accommodations, just having to do with the employer making assumptions again that someone has a disability when in reality they don't. So an example we have is someone who has a skin condition that causes some redness on their skin, and it's kind of obvious to everybody. And the employer decides not, and this person applies for a front desk receptionist job, and the employer decides, you know what, we're not going to hire you because that's going to be off-putting for the customers. Well, in this case, there is no actual disability. This skin condition doesn't affect any major life activity. We don't have a disability under the ADA. What we do have is the employer taking some adverse employment action based on an assumption that what is physically present is actually a disability, and and illegally discriminates against this potential employee on that case. So that's, we see that a lot too, right? So this idea that um, you know it's kind of overt discrimination based on something that would be a disability, or not, that isn't a disability, but the employer actually assumes that it is.
Yeah, I like that example because it kind of, I mean, we're not just talking mental health. We're not just talking drugs and alcohol. It could really be anything. And that one kind of underscores this whole concept of, in order to be a disability under the ADA, it has to substantially limit one or more major life activities. And there might be things that you can see or observe that just don't, right? How would that have impacted the major life activity? In that case, the employer had no idea, right? They didn't have any info. They were just going on maybe personal, bias or what they observed and making assumptions from there. So I think that's a good example.
And assuming that it would actually affect the person's ability to do the job. Assuming that people would find it off-putting, right? There were a lot of assumptions baked into Doug's example, for sure.
Yeah. So kind of going back to what Jennifer said, for sure, if you've got a safety sensitive position, and law enforcement is the example that comes to mind there, as well as maybe like heavy equipment operators. I mean, safety sensitive positions always have a little bit extra, I guess, extra tools they can use under the ADA. And again, these are fairly complex tools. I wouldn't do these without calling for legal counsel first, because there's a lot of guardrails on the use of those tools. But like Jennifer said, if you see someone in a safety sensitive position, and if employees are reporting that they're impaired or acting abnormally, something that might impact their ability to do their job, we're certainly not saying ignore it. That's not the point here. Like, fitness for duty is a valid concept under the ADA. It's just, it has to be used in the right way with the right documentation after an employer has gathered enough evidence to trigger the use of that mechanism. But fitness for duty, definitely a concept if you're managing people in a safety sensitive role you would want to be aware of. So I guess a couple other takeaways for employers as they're thinking about how they can avoid regarded as discrimination claims. You've heard Jennifer talk about avoiding assumptions, Doug, too. Any other tips you guys have for employers as they consider this concept and things they can do to make sure they don't end up with a claim or a lawsuit for regarded as disability discrimination?
Well, I mean, we're always big on training here, but I do think training. I think your HR personnel may already know this, but making sure that your HR folks and your supervisors are aware that this is a concept and it exists, and to give them the tool of, asking, do you need help? And again, to caution them against making snap decisions based on assumptions. Again, there is a bit of a caveat for some of those safety sensitive positions, but overall, in general, under the ADA, and even with safety sensitive things, you do want to have some level of information, facts, and evidence to support the decision that you are making. And you want your people to know enough to recognize those situations and kind of triage them and handle them when they come up, and then know when it's appropriate and necessary to escalate them to address them further. And then also, I think, when the tool is available to you, knowing how to do it and how to do it properly. So, like the interactive process, which I think we've talked about here before, but that really is the process where you engage with the employee to get information from them, from their healthcare provider, to help figure out what are the limitations on the job, how it affects the job, if they have a disability that is impacting them at work.
And just and what we all the other thing that we always kind of harp on here is, other than training, is policies, right? So Jennifer just mentioned the interactive process. Have clear ADA policies in your handbook, so that employees and supervisors alike both understand how to request an accommodation, and how to go through the interactive process, and get the employees and the employer what they need.
Yeah, jumping on that bandwagon a little bit. So not only making sure your supervisors generally understand what the ADA is, but they really need to be able to spot issues, right? So what would they do if they see someone who's impaired in the workplace? Do they know the protocol for getting a drug test, an alcohol test? Do they know who to go to raise that as a concern? Do they know and understand how timeliness is so key when you have an issue like that come up? Those are the types of training. The high level, here's how to spot issues, here's your responsibilities as a supervisor, here's who you go to for the deeper dive on the ADA piece. And piggybacking on that, what Doug just said, with employers, that drug alcohol testing protocol policy is a tricky one, right? Do you have the right policy in place to know when you're going to get someone tested? What kind of observations are needed? Who's responsible for it? Where would they go? Those are all issues that kind of have a tendency to relate to regarded as disability. With mental health, do your supervisors know how to spot issues related to possible disabilities there? And then again, what Jennifer was talking about with following this structured ADA process, do you have somebody in house who's making sure that if someone does get asked the question, do you need help? And if they say yes, the ADA file gets opened and the interactive process letter gets sent to them, so they know to take it to their healthcare provider, so that you're actually getting third party info you can rely on, again, rather than just relying on your own assumptions and stereotypes. That to me is probably the step that employers skip the most, that causes the most problems, because if you don't get the healthcare provider telling you which essential functions are impacted and how, that just ties an employer's hands for getting through the ADA accommodation process. It makes it about impossible. That's so important, to give the employee the ADA accommodation letter and to get their healthcare provider to tell you what types of functions are impacted and what possible accommodations are.
And I'll throw on that little pile there job descriptions. And we've talked about that before in the context of the ADA. And job descriptions really are just very important core concept under the ADA. And with regarded as claims, a job description is what will tell the employer what the essential functions of this person's job are and what is expected of them and what they need to be able to do in terms of performance at work. And to even know whether you have a reason to even be thinking that there might be an issue, you're going to need a job description to be using to evaluate the person's performance. With conduct, sometimes it's the handbook and policies that help you there. But really having those base tools in place will be helpful. And then if you end up asking the question, as Pam said, of do you need help? And the person says yes, that job description is what you will then be providing to the employee to give to their healthcare provider to facilitate getting that information about how and to what extent whatever is happening is impacting them at work and what reasonable accommodations might exist. If the person doesn't actually have a disability, you don't have to accommodate them. But really, for the regarded as claims, all of those tools, good policies, good job description, having had training is going to help you to start off on the right foot, asking the right questions, and then figuring out whether this actually is a circumstance where you then need to move to the next step of going through the interactive process. And then those tools will help you there too.
Yep. So if you're listening to this and you're thinking, boy, we need some training on that, we have some solutions for you, as you probably know, maybe if you've listened to our podcast before. So we're big on training. A little bit of training on the front end could help you avoid claims, lawsuits, legal fees, and the basic nightmare that goes along with everything that happens when an employer gets drawn into a lawsuit. So we have our Law for Leaders training. We've got recorded content, which does include several sessions on the ADA, the exact type of stuff we're talking about today. We do in-person training, and we do a mix of both. So we seem to be having more and more clients who are buying the recorded content and then having us come and reinforce that by in-person live training too. So you get that interactive piece. And so employees get a chance, the supervisors get a chance to ask questions and kind of tie it all back into what's going on in the workplace. So we've got training solutions there. And then, of course, we have our book that we published in January, Law for Leaders, the roadmap every leader needs to know to avoid workplace claims and lawsuits. That has chapters 8, 9, and 10, which all talk about the ADA and really tie into exactly what we're talking about today. So that's it for today on Ground Rules. We hope you got a little something out of that. We recognize how complicated the ADA is, and we're committed to trying to help you understand and navigate the ADA to avoid claims and lawsuits. So that's it for today. See you next time on Ground Rules.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.